Good morning, everybody. My name is Nicholas Somberg. I'm a criminal defense attorney. I represented Michonne Maddock in this case, and I appreciate all of you inviting me to come and testify here today. I appear not only as Michonne's lawyer, but somebody who deeply cares about the Constitution, civil rights, our justice system, and the misuse of state power against ordinary citizens. A lot of the facts have already been placed on the record here today. I just want to emphasize that these people who were charged, they weren't criminals. No one had a criminal record. They're veterans, parents, grandparents, city clerks, small business owners, farmers. They're ordinary Michiganders who were called to serve as Republican electors and elected to do so for the 2020 presidential election. Something that until this case was a normal part of the political process. My client and the other electors had to deal with over 2 years of litigation, and it's still not over. There's still a civil case going on and maybe the potential for appeal. Judge Simmons dismissed all 120 felonies. We get that number from the 15 remaining electors times 8 apiece. And being dismissed at the stage of preliminary exam, that is the best you can get. That's better than if you win at jury trial, you're not guilty. So a jury could think, well, maybe they did it, but it's not beyond a reasonable doubt. It's not they're not guilty. And that's an exoneration. But to be at preliminary exam where the state just has to show probable cause, just a question of fact for the jury. So if you're robbed, right, and you get subpoenaed to go up to court, it's simply you show up and say, that's the guy who robbed me. That's it. And the other person can say, no, it wasn't me. Those two different sets of facts, question of fact for the jury. It goes forward just based on that. So if Judge Simmons says that there's not even a question of fact, there's not even probable cause, well, I'd say that's better than beyond a reasonable doubt. That is no doubt. There is no doubt that these people were innocent and that not even a crime occurred. And this is an extraordinary outcome. I want to reiterate, this doesn't even meet the preponderance of the evidence standard, and at the preliminary exam stage, all the facts taken in I was in group 1, we had 6 complete days of preliminary exam testimony, that the facts are taken in the light most favorable to the prosecution at that stage. So when you motion to bind over, to not bind over, to move the case up to circuit court, the facts on the record are taken in the light most favorable to the prosecution, even that complete dismissal across the board. Attorney General Dana Nessel's own public admissions. I noticed this right away. We tried to bring this up at the first hearing of the first group to Judge Simmons, and Judge Simmons basically said this is not a consideration in dismissing a case at exam. And she's right, but I've never seen an attorney from the other side, let alone the highest law enforcement person in the state, the highest lawyer in the state, go on publicly admit and concede her entire case before it began. They're brainwashed. They genuinely believe Trump won. They couldn't plead guilty if they wanted to. It's like charging somebody with grand larceny, theft, and then going on TV and saying, well, they didn't mean to take anything. It was an accident. Okay, case dismissed. It's like charging somebody with premeditated first-degree murder and saying, well, it was an accident. Okay, then the case is over. There were statements by other attorneys that were stunned by our comments, one calling it a gift to the defense. It's really a gift after facts. We still have to go through 2 years. Dana Nessel pressed forward with one of the most damaging prosecutions in our state's history. The toll on my client and the other electors has been enormous. For 2 years, they lived under the weight of multiple felony charges, carrying up to a maximum of 14 years in prison. One of those individuals took a deal for immunity to essentially testify for the Attorney General. And even his testimony said that they did nothing wrong. Families were devastated by this prosecution. Michonne's stepmother passed away during this case, not knowing whether or not her daughter would ultimately be cleared or spend years in prison. Her father's now in hospice, carried the weight of this worry every single day. Her children lived in fear of losing their jobs because of guilt by association. And her daughter did lose her job at a nonprofit, almost certainly because of these politically charged accusations. John Haggard passed away just hours after the dismissal. There were defendants even through this that were in such poor health they couldn't appear at court. For more than 30 years, Michonne and her husband, Matt Maddock, is here today, maintained a business account with a prominent national bank. About 6 months after Michonne's charges, they received a letter from the bank telling them to take their money and go. No reason was given. Their entire business infrastructure was tied to this account. Payroll vendors, client transactions, all had to be untangled overnight. After 3 decades of loyal banking, they were abruptly treated as if they were radioactive, solely because the felony charges had been filed against Michonne. Charges that, as we know and knew from the beginning, should have never even been charged in the first place. There was a humiliation of travel restrictions. For 6 months, Michonne was unable to leave the state without the court's permission. In the beginning of this case, we made a formal request to attend a professional conference in Minnesota, a conference directly relevant to her political work and civil work. This was hosted by Mike Lindell. We sent a formal travel request. The Attorney General's office denied that request, in their words, comparing it to sending an alcoholic to a wine conference. So again, the purpose of bond is to assure somebody comes back to court. If somebody's charged with a DUI, you don't send them to spring break Cancun, for example. But the AG's reasons for not letting them go was not because they weren't concerned that she's going to come back or not. Was because she's actually discriminating against the content of the speech that she was going to hear. And she compared that content to alcohol and compared her to an alcoholic going to a wine conference. So this analogy is not only insulting and demeaning, it mocked her faith and her politics and publicly painted her as someone unfit to be trusted to attend a professional gathering. This was punishment before trial, designed not to protect the public or reassure her appearance at court, but to degrade her reputation. I'd like to bring up also that regarding the travel restrictions on day 2 from the first group of this case, this was about a week before Christmas, and one of the attorneys asked for their client to be able to travel out of state to see their family for Christmas. And Judge Simmons, now hearing 2 days of testimony, said, after her words were, "After what I've heard these last 2 days, I'm lifting all travel restrictions on all defendants." Now that's amazing. Somebody facing eight felonies, and I could tell just the look on her face throughout the 2 hearings were like, this was not what I thought. This is not what I thought. This is not what I heard in the news that these people were accused of doing. I thought that they tried to steal and overthrow an election. But they, just by day 2, it was, they legitimately did nothing wrong. And all travel restrictions lifted on all defendants. Beginning of this case, you heard about some of the financial toll brought to everybody involved here. Dana Nessel subpoenaed Give, Send, Go. This is a Christian crowdsourcing platform to raise money so everyone could have, we needed 15 lawyers in this case. Everyone had to have their own lawyer. This was to raise money to help for their defense. I've never heard of a prosecutor subpoenaing a charity website so somebody could raise that. That's concerning in and of itself. But then you have a right, Sixth Amendment right to counsel, and you have your right to your choice of counsel. So she is subpoenaed, give, send, go for what? What evidence would you even find in that to prove any element of any of the charges in her case? And she did that to intimidate the donors. It worked. The donation stopped. Give, send, go, I believe stopped the even ability to donate to them. And those donations are essentially their First Amendment right to vote with their dollars. They say, I support Michonne. I support the electors. I want to donate to them. Well, now they can't, or at least can't in that way. And they shut down a major avenue where they could get money for their defense. I call that intimidation. Dana Nessel held repeated press conferences where she exaggerated, misstated, and outright contradicted the evidence in her own case, even after the dismissal. It's like she still doesn't even get it, what she did. She doubled down, telling public and that the defense knew they were lying, knew they were not electors. But her own witnesses, Judge Simmons' words were the AG's own witnesses confirmed the electors believed they were acting lawfully. This is not how justice should work. Prosecutors are not supposed to be political. They are supposed to be ministers of justice. And I cannot imagine being the attorney general and having such a high prestigious office and using that to go after people I just disagree with or don't like and being public about it. It's one thing to hold your own opinions and say, I don't like Republican, around your dinner table or with friends, but to just go on TV and be open about this stuff. As lawyers, we have rules of professional ethics. Prosecutors and judges both have extra professional ethical rules that apply to them because they're in positions of power. Michigan Rule of Professional Conduct 3.8 states, the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Berger versus United States, a U.S. Supreme Court case, says the representative of a sovereignty whose interest in a criminal prosecution is not that she'll win the case, but that justice shall be done. When the Attorney General admits the defendants lack the records and intent, her ethical duty is to stop right there, not double down and drag them through the mud for 2 years. Pressing forward anyway weaponizes the office and erodes public trust. I would say that even we had the general counsel to the U.S. Senate testify, and I asked him, I go, well, you guys probably there's 320 million people in this country. You guys probably get some interesting mail at time to time. You probably get some people claiming to be Jesus or the president, right? He said, sir, yes. And I asked him, well, have you ever gotten mail of somebody claiming to be an elector, that they're casting their vote in the Electoral College? He said, yes. Next question, were they ever prosecuted, to your knowledge? No. So this was the first time in U.S. history that people were prosecuted for election fraud, forgery, conspiracy, 8 felonies for signing their name to a piece of paper. And I like to just bring things to logical conclusions. Logic has to be consistent, even if it's, ridiculous. And if you were just some bum on the street and you wrote down on a napkin, I declare I am the President of the United States of America, and that homeless person mails that napkin to the White House, do we hunt him down and charge him with 8 felonies? No. Okay. Waste of public resources. This investigation, first of all, my office is going to be filing a Freedom of Information request to find out the entirety of every dollar spent to date from the investigation and prosecution of this entire case. This must be enormous. I can't imagine. This dragged out for over 2 years. Our discovery that we received is in the terabytes of content, so that the video, the audio that had to be produced, the amount of time compiling this must be untold hours of state resources, from officers to lawyers. We are going to find out how much was spent on this complete collapse case. The people of Michigan deserve to know how much money was wasted on what amounted to a political vendetta. It was not just a bad prosecution, it's a dangerous precedent. If citizens can be charged with felonies for engaging in a political process, even one later determined to be unsuccessful or purely symbolic, then free speech and political participation are at risk. This case criminalized politics. It weaponized the legal system to punish opponents. It inflicted lasting damage on families and communities, and it wasted potentially millions of dollars that could have gone to public safety, education, or real crime. Michonne and the other electors can never really be made whole, and they faced attacks. This is extremely public, and their reputations on social media, the threats to themselves and their family are crazy, and I've seen them, and you kind of see what can happen, based on the events with Charlie Kirk last week, and they're given very direct threats and just extremely hateful things. And to me, it's because what they were even accused of was spun so much by the media and Dana Nessel, and it wasn't even given factually. She's on TV saying they tried to overthrow the election and that they committed crimes, and they did it. It wasn't even what Dana Nessel is going on TV and continuing to repeat is not even what happened. So she doesn't even understand her own investigation. Okay. Some suggestions I think for reform. One, prosecutor accountability. Prosecutors have near complete immunity, but there needs to be some sort of line where a prosecutor can be held personally responsible because it's not their resources. And like in this case, maybe Dana Nessel knew from the beginning that this was going to fail. But the process is the punishment. So she has the power, and that's why she has the extra ethical duties. She has the power to cost people their freedom, their money, years of their life, and she can get away with it. So maybe there should be some sort of line that, to make a simple example, if you're a prosecutor in a little court, and you break up with your boyfriend, and so you just charge him with a crime to get back at him. That as of now, that person can get away with it, and there should be some sort of mens rea requirement for a prosecutor that, hey, if you knowingly use your office, your position to prosecute somebody, you should be maybe prosecuted yourself, or at least open to some sort of hit to your pocketbook. Maybe you have to pay the person's legal fees or something like that. I think there's a reasonable middle ground there. Donor protection laws. It should be a law that you can't target donors to somebody's legal defense. I think that's in violation of the Sixth Amendment and First Amendment. Absent clear and compelling evidence of criminal activity. So if there's a mafia donating to their own mafia, maybe that's an exception. But there should be clear and convincing evidence of criminal activity. You can't target donors to assist in someone's legal defense. I just want to close by thanking and just recognizing the courage of Judge Simmons. It took a lot. I knew factually and logically from the beginning, day one, that there was no case here. But Dana Nessel I felt like she really lined this up. She's like, okay, we got the Whitmer-appointed Democrat judge, and we got the Democrat jury, by her own words. That Judge Simmons, it took a lot of courage. And just I'll show you the complete baselessness of this case. You would think I think she was very fair throughout the whole trial, extremely fair. I'm like, wow, she's on it, she gets it. But it took a lot to just go against her party and her. It was not an easy decision, and I couldn't imagine the political pressure she was facing. But she applied the law fairly, and on behalf of my client and the other electors who suffered through this ordeal, I urge you to pursue reforms and oversight to ensure that this never happens again. And thank you for the opportunity to testify. I'm happy to answer your questions.
Thank you, Mr. Somberg. So I just have a few questions that we'll turn over to the committee members. But I was kind of taken back when you spoke about Dana Nessel comparing, allowing these, defendants to travel outside of the state, and somehow she's comparing this to alcohol. I think that's very inappropriate and unprofessional, especially of an attorney general who had to be wheeled out of a college football game because she had an issue with alcohol. So I don't think that's a laughing matter. Regarding the FOIAs, you would like to request for FOIAs for the dollars spent by Dana Nessel's office regarding this case. Save your money, because I will be making that request. I know that they're very expensive, and I'm sure that the amount of documents regarding this case going back, 2 years has got to be very, very, very thick.
Thank you.
So you're welcome. You're welcome. And Shriver? Representative Shriver's got a question?
Thank you, Madam Chair. This whole issue of debanking is insane. We, the people, must run America, not the banks. What can be done to prevent debanking of innocent Americans?
Well, we have laws in place that you can't refuse somebody's service based on their race, religion, sex. We have equal housing laws. Honestly, a private bank, I believe in capitalism and freedom to conduct business and refuse business. So I don't think a private bank should be allowed to. A private business can refuse service to anybody, per my beliefs. But however, I was just bringing up the point that the bank chose to stop service with them because of this farce.
Thank you.
So Judge Simmons noted, typically people who are seeking to defraud or deceive the public do not gather and make a spectacle of that. Number one, do you think that the Attorney General ignored the fact that your clients acted publicly, not in secret, when she claimed this was a criminal conspiracy?
Yes. And when you're conducting an investigation, I'm not an investigator, I'm not a detective, but I went on Michonne's Facebook, and the day that this happened, she publicly posted her intent. We are submitting this as an alternate contingency plan because we believe there is potentially election fraud. This is what we are being told, and we are submitting this as a contingency election slate, period. Day one. And by the way, this is not somebody trying to cover their tracks, because Michonne's not a lawyer, and nothing like this has been charged ever in U.S. history. So it's not like somebody who goes out and commits a crime. They, rob a 7-Eleven, and then they make some sort of post being like, well, I was in Aruba that day or something to cover their tracks, because they know what they did was a crime. Michonne was posting genuinely and honestly stating her intent, and there was no evidence, not a shred of evidence to go against that throughout the entire prosecution.
Mm-hmm. Right.
I did want to just mention one thing, just to keep the record clear. The statement comparing this Michonne's belief to alcoholism, that Dana Nessel didn't make that statement. It was her assistant attorney general.
Oh, the assistant. Okay.
Yeah, but
Thank you.
But I don't know, maybe it came down the chain, but she did not make that statement.
Okay. Thank you for clarification on that one. Did the timing of these the charges coming years after that election?
Yeah.
But before the next campaign season, did that seem politically motivated as well?
Yes, and
I think everything in this case was politically motivated.
it's not a big coincidence. I'll say in my opinion, and maybe ironically, I think Dana Nessel was trying to interfere with the 2024 election, because these are not just these are not just random people off the street. These were Trump's main advocates, fighters, volunteers from the beginning, from 2016. These are his main people that helped him get elected in 2016, that fought for him in 2020, and never gave up and continued fighting open for him in 2024. And when you charge people with 8 felonies apiece, cost them tens of thousands or hundreds of thousands of dollars, threaten them with years in prison, hurt them financially, morally, their morale. Also, she went after his main people that would be the organizers of events and speeches.
The most influential supporters in our state.
Yeah, his main boots on the ground here in the state. And it's not an accident. Why'd she wait 3 years to do it? She could have did it right away. And she also had the Ingham County prosecutor first deny. And I use that as part of my brief to dismiss their very own logic, reasoning, and case law. Ingham County prosecutor says this is simply not even a crime. Why wait so long? It's for the timing to just add a 1-ton weight to their leg for the 2024 election and to scare other people.
Well, I would even make the statement that it felt like, especially with your client being a high-profile candidate to chair our Republican Party in Michigan, how this case and these charges affected the outcome of that race as well.
Of course.
Because it was so controversial. I hadn't seen all the facts and everything to do with this case until this morning. And, our Attorney General has a history of weaponizing her office.
Yes.
It's not a secret. She doesn't make it a secret. She's gone publicly after hairstylists, after restaurant owners, and it's just a continuing pattern with this Attorney General.
Yeah, she's made a really amazing public comment. She doesn't like Republicans. During COVID, she's like, I'm sick of hearing about these white golfers when we have black nurses that need our attention. Why refer to white and black? What's the point? She's referred, said how offended and devastated she was to hear the words Merry Christmas. So every single defendant was a white Christian Republican. And we know her political beliefs and her beliefs about these types of people because she states them publicly. She doesn't hide it. It's amazing.
Well, just as Judge Simmons said in the courtroom, in this courtroom, this is her quote directly, "We don't care about your race, color, creed, national origin, or political affiliation. We care about the law." And I would encourage Dana Nessel to also live by that quote.
Yeah, it's amazing. That's what a judge should do in anybody in an
Absolutely.
elected position.
Absolutely. Are there any more questions for the committee? Okay. Representative Pahutsky moves to excuse absent members. Hearing no objection, the motion prevails. There'll be no further business before the committee. The meeting stands adjourned.